Morning, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff. My client is in the courtroom as well. Today is the scheduled date for trial.
Patrick Brooks. Being no response, you'd raise your right hand, take it to call. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead. What is
Your Honor, plaintiff requests a default judgment for possession only. The amount of rent due is $3,639. That includes July's rent, $175 in court costs, for a total amount due of $3,814. We would ask that default judgment be entered, requiring the payment within 10 days, or writ to issue. Partial payment shall not stay the issuance of the writ. There's no money judgment at this time.
judgment to the plaintiff? That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Thank you.
I'll submit the judgment by email.
That'll work.
Thank you.
That'll work. Sorry about the delay, sir.
Thank you. Have a good week.
You too. This is whatever. Patrick Tatura versus Martin Youngs.
Do you need to see?
No, he won't be staying long.
I hope that's the case, Judge.
Me too.
Good morning, Your Honor. May it please the court, Eric Wadef, P65354 on behalf of plaintiffs.
Good morning, Darwin Fair, defendant P number 31266.
The plaintiff filed a motion to lift the stay and enter an order of eviction. At the time, I had not received a response, but I thought I wasn't sure where other proceedings were. I realized what was represented in the motion. And so I set this for hearing. So.
Well, Judge, I hope we would not be here today. We've been down this road a number of times, and your question is always the same question, and the answer is always the same answer, which is the Wayne County Circuit Court has not closed the file. There's still pending actions in front of the Wayne County Circuit Court that impact on the issue that's before this court. So unless we're here to argue the Wayne County Circuit Court motion, I don't know what more to say to the judge. There's really nothing more to say.
This property is located in Washtenaw County, however.
Where's it?
Yes, it is, Your Honor.
Yeah,
Yes.
the property is in Washtenaw, so I'm not clear why I'm worried about anything being litigated in Wayne County.
Well, what happened?
Let me rephrase that. I don't know why I would be worried about that with reference to this active proceeding forth in the eviction happening.
Well, the reason, Judge, is for the same reasons that occurred multiple times before this court, which is the property in Washtenaw County is subject to a settlement agreement that was entered into with the Wayne County Circuit Court judge. So this is part and parcel of this global settlement. And the reality of it is that this case on this property is still subject to the jurisdiction of the Wayne County Circuit Court judge, as has been the case every time we get before this court. As every time we get before this court, it's the same issue, Judge. And now this is, I will admit, this is the first time I've heard the court say this, but the reality is still the reality. This property is part of, and Judge, I know you do not want me to repeat myself, and I don't like to repeat myself, but I'm a little concerned that if this is not being gotten across, is every time we get to come to court, it's because of the same issues of this global settlement that is before the Wayne County Circuit Court judge.
Well, no. Before I would, right. I mean, the reason the case is here is for whatever its reasons. But part of the reason that things were stayed is because clearly it was headed up the chain the appellate chain. My understanding is that's no longer the case.
No, no. And let me,
Know that,
no, that's not the case. And so let me explain it this way, Judge, because I'm trying to get into your head. What the court, I think, is concerned about is the Washtenaw County Circuit Court case that directly impact this case. And that case, the Washtenaw County Circuit Court case, which was appealed to the Michigan Court of Appeals.
right,
Okay, that case was dismissed, Judge, as a result of a global settlement that is before the Wayne County Circuit Court judge. So what happens in this case is still being handled by the Wayne County Circuit Court judge because the Washtenaw County case, which was appealed to the Michigan Court of Appeals, was voluntarily dismissed as a result of the settlement.
let me cut to the chase. Why wouldn't I just lift my stay, issue the order of eviction, allow it to be executed at some future time, that they couldn't do it right away? Allow it to be executed at some future time. And if you're correct, then get a stay from Wayne County.
Okay, well, Judge, okay, now, and I'm hearing you, and I'll walk down that road with you. So the issue of the quote unquote eviction is a function of the ownership of the subject property. The ownership of the subject property is specifically before the Wayne County Circuit Court judge. So let's assume that the court says, okay, I mean, enough's enough, although it's the same issue that has been before this court multiple times, and the court says the same thing multiple times, which is, I'm not going to do anything until the Wayne County Circuit Court has made a decision, which is what, okay.
I don't know that I said anything about Wayne County.
No,
I think I said something about Washtenaw County and the Court of Appeals and the Supreme Court.
no.
Go ahead.
No. It's never about the Washtenaw County. It's always about Wayne County. It's always about Wayne County. It's never about Washtenaw County, because Washtenaw County, Judge, again, was appealed to the Michigan Court of Appeals. It was voluntarily dismissed as a result of the global settlement that was before Wayne County Circuit Court judge.
And Mr. Fair, I'm saying, let's assume for the sake of argument that you're correct. I have a feeling there's going to be disagreement as to what you're saying in part. But why then wouldn't I just grant the relief, issue the order, and then you get a stay of that and allow an opportunity, so I wouldn't have it where it could be executed immediately, give you an opportunity to then get before the Wayne County Circuit Court, which you're saying this property is part of some global settlement, and allow that court to basically stay any order of eviction or enjoin the plaintiffs in this case from moving forward.
Okay, Judge, allow me to walk down that road. Okay, so
Why is that a hard question? I don't need to be walked down the road. Why is that a difficult question to answer?
because the hearing, no, because the hearing that you're making reference to, that I should go before the Wayne County Circuit Court judge and ask for a stay, is a hearing that is essentially scheduled for July the 18th. That hearing will address the very point this court is making. So what?
Then why don't I grant the relief, indicate that the writ cannot be executed until, if your hearing's on the 28th of July,
No, 18th. I'm sorry.
that it can't be executed until the 28th of July, giving the 10-day statutory period from the time of that hearing.
Okay, Judge, this is the road we always walk down, because what happens is on the 18th, we don't know what Judge Ewell will do. Judge Ewell may say, I'm not going to hear it on the 18th. Or, and Judge, I'm only going by what's happened in the past, and it's safe.
Sorry, raising questions.
You're gonna have to leave. You're gonna have to leave.
I do not want to argue, Judge.
Go
Pete
ahead.
Davis' case. So what has happened in the past, which is probably what's going to happen today, is that on the 18th, Judge Ewell will do one of two things, which has happened in the past. When this issue is before this court, Judge Ewell may or may not hear the case on the 18th, or may hear the case on the 18th and then decide not to make a decision until sometime in the future. Now, again, Judge, I'm not saying this for the first time. This has been the history of this case. Now, if we look at what happened, they filed a motion to go before the Wayne County Circuit Court judge, and it was scheduled for the following Friday. At the same time, they filed this motion in front of you and filed a motion in front of the 35th District Court, assuming that the Wayne County Circuit Court judge would close the file. Because I will tell you, Judge, the question that you always ask, this is the question you always ask: what's the status of the Wayne County Circuit Court case? Is it open or is it closed? The answer is always the same. It's open. Your response is always the same. Well, I'm not going to do anything until the Wayne County Circuit Court makes a decision. And then a couple of times, Judge, you said, I'm going to adjourn it to right after when the circuit court judge makes a decision.
So why don't I put an end to that and just grant their relief?
Well, because, Judge,
Because it doesn't leave you, Mr. Fair, without remedy. Because you can always ask the Wayne County Circuit Court, as I've said, to either stay that writ if they've taken some jurisdiction over this property, or to enjoin the defendants from proceeding on the writ that I would issue.
well, Judge, this is a conversation we've had at nauseam all the time. And
Well, I'm trying to end it.
And what I think but I think, Judge, what you recognize is, well, that means I've got to run to the Wayne County Circuit, Wayne County Circuit Court, ask for a stay. The judge is going to say, aren't we going to be hearing this on the 18th? And then on the 18th, like what has happened in the past.
Well, hold on a
said-
second. No, you wouldn't have to do that if you would listen to what I'm saying. What I'm saying is I could grant the plaintiff's relief. They could not do anything, and I'm not even saying on the 18th. I'm saying for a 10-day period after that hearing. So if the judge at that point in Wayne County doesn't do anything, the 10-day statutory period would begin to run on the writ.
Wait a minute, if he, wait, Judge, okay, so the motion that is before the Wayne County Circuit Court, which plaintiff acknowledges affects what this court can do. What they're asking the Wayne County Circuit Court is close the case, close it. And then if it's closed, then they can come to you and say, hey, Judge, it's closed. So let's go back to that point. On the 18th, if the judge does not close it, if the judge does what he has done in the
If
past.
judge does not close it, you could request of the judge to enjoin the plaintiffs from proceeding forward. If the judge does close it, the writ would proceed.
Well,
That seems really simple to me.
the 10 days after that.
Right, 10 days after.
But that means a couple things. Number one, if I'm hearing the court is saying, well, if it gets adjourned to August the 10th, August the 18th, another month. And if at that time, the judge closes it, that means in this interim period between July the 18th and August the 18th, by definition, they can't do anything.
No. I'm not saying that.
Okay.
What I'm saying is you're saying the Wayne County Circuit Court has that this is part of some global resolution.
Correct.
Okay, I'll take you at your word for that. I've not seen the resolution. That's fine. It doesn't matter to me. What I am saying is, I will assume you to be correct. I will assume also that Judge Yule will act within his authority regarding any agreement there is. Right?
Correct.
So if I grant the plaintiff's relief, built into that are enough protections for the defendant in terms of being able to request of Judge Yule to enjoin the plaintiffs from acting. If that case is going to be adjourned out, or he doesn't rule on that day.
No, okay, Judge. And I'm not going to belabor the point. I'm going to put the past in the past because we've always in this situation, and your position is real simple. Is it open or closed? If it's closed, if it's
No.
open.
The question is it pending or not?
Okay.
So if the
Still
issue, Mr. Freeman, if the issue before this court is pending somewhere elsewhere,
Correct.
that is always what I will address.
Correct.
And I think properly so. It doesn't sound like that's what's happening here. It sounds to me, based upon what you're saying, and again, I haven't seen it, that there is some resolution of this global resolution, whatever it is. I'm saying, fine. There are still issues to be decided with that. They don't need to be decided here. And so that I could grant the relief that the plaintiff requests with enough safeguards that protect the defendant until whatever that issue to be resolved is.
Well, if the court is saying that the plaintiff in this case cannot act upon any decisions of this court pending.
That is not what I am saying. That is not what I'm saying, and you know that's not what I'm saying.
Can I ask you a question? Judge, my client wants to ask a question. You say yes.
Go ahead.
Go ahead.
I mean, we did everything. It seems like we get penalized every time, not in your court so much, but we do everything. We had a global settlement. 3 pieces of property, 1 in Washington, 2 in Wayne County. We all signed, the lawyers all signed what had to be done to get that done. We do everything in the agreement. My family, everything in agreement. They refused to sign a paper, and we're here. And we're getting penalized by getting an eviction. No matter how you rule it, it's against us. Whether we settle something on the 18th or not. We're not supposed to even be here. This is a pending case in Wayne County Court that we all agreed to settle. That guy has the ruling. I don't know what we're even here for.
You, like your attorney, are not listening to me.
You're
I
saying you're
take
gonna
you
rule
at, if
and
you
give
want
them
to
their flag.
interrupt me, then you go right ahead.
No, I'm sorry. It's just, I've done everything for 7 years. I've worked up in this, and I've got, his client has jerked me around for 7 years. Well, and I haven't been able to live in a house I built. And then I'm gonna get an eviction notice that I know doesn't mean anything to you guys, but to my family, it means everything.
Sir, maybe you and your attorney should listen to what the court is proposing to do. Because both of you have been saying the same thing, that there is this agreement out there that is subject to the jurisdiction of the Wayne County Circuit Court. I'm not going to even begin to get involved in that.
Right. If you're, can I say one thing? I'm sorry, I'll leave.
No,
It's
no,
just-
no.
No, it's,
No.
he doesn't get it.
Judge didn't say. he
He's
couldn't.
always been
Hold it,
good,
hold it.
but
Judge didn't say
I
he
gotta
couldn't.
get out of here before I have a breakdown, man.
Yeah, Judge didn't say he couldn't say it, so why don't you say it?
All I am saying is, there is this agreement. I've not read this agreement. I don't know what this agreement is per se in terms of how the court is ruling. Not even in a lot of ways have detailed specifics about what needs to be decided. Maybe the issues, sir, that you're raising need to be decided. What I'm saying is, as to this property, if indeed that's going to be decided in Wayne County as part of this agreement, I'm going to issue the order, I would issue the order of eviction, subject to the date that your next hearing is, and giving enough time so that your interest in regard to that settlement can be protected by Mr. Fair. That's all I am saying. I'm not ruling that there's going to be an eviction. I'm not ruling any of that.
Then why rule at all?
Because it's my job.
Okay.
Sit down.
Sorry.
Judge, can we rest at this point, and then I have a rebuttal after you speak to brother counsel? You know,
I worked on this.
He needs to get out.
well, yeah.
I think you better go out. I'm gonna pass it briefly. You
Whoa.
need to go out and check your
Oh,
client.
no, Judge.
No, go out and check your client.
I will, Judge, but he's fine.
Avalon Housing versus Yolanda Shep.
Very good morning, hearing for plaintiff. Which case? Okay, Your Honor, I was assisting this woman. I just need to give her some information and then I'll be ready. She's right here. If you,
You,
do you want to pass?
apparently,
Sorry, Your
court
Honor.
calls the case of Faith Shepherd versus Lakrita Thompson.
Carissa Gazari. I'm just gonna, my client is in the hall. Is it okay?
Yes.
Sorry, Your Honor, I was assisting a member of the public navigating the courthouse.
Your name, ma'am?
Lakrita Thompson.
Come on now. You're at least ready.
Your Honor, client is coming in as well. I had a chance to speak with Ms. Thompson. We have an agreement to place on the record.
All right, go ahead.
Your Honor, this case was filed as a termination of tenancy case. Following the filing of this case, Ms. Thompson provided to Ms. Shepherd's daughter a copy of a lease that had been signed, I believe, by Ms. Shepherd's ex-husband. The copy that I have is not signed by the tenant. In any event, we're willing to allow her to stay until September 30th pursuant to certain terms. So we've agreed to a conditional order of dismissal. The case will be dismissed without prejudice. As of now, there is $1,600 due for rent for April, May, June, and July. Ms. Thompson has agreed to pay $2,000, which includes rent for August, to Ms. Shepherd, either Ms. Shepherd or her
Well,
daughter.
the 16, oh, it included July because it is July 1st. Never
Yes.
mind. I'm sorry. Go ahead.
So it's going to be a total of $2,000. She is going to pay it in cash and then is going to receive a receipt tomorrow at 4:00 at the lease premises.
Got it.
Ms. Thompson is also going to pay the water bill that was due on June 26th in the amount of $233.94 directly to the agency by tomorrow.
Okay.
In addition, she is going to vacate the lease premises by September 30th. She's going to turn in her keys for the lease premises to plaintiff by September 30th. She's going to pay her September rent to plaintiff by mailing a check. She has the address postmarked on September 2nd because of the holiday.
Okay.
She's also going to comply with the lease. In terms of utilities, she is going to pay her utilities timely as she's required to in the lease. She pays utilities for water, gas, and electric. This is the downstairs unit that Ms. Thompson resides in. There will be a tenant at some point moving into the upstairs unit. It may be, mid to end July, it may be August. When that happens, for any utility usage, for time following when the tenants have moved in, plaintiff will split those utilities 50-50 with Ms. Thompson until September 30th. So it'll be probably maybe August,
Yeah.
something like that.
Okay.
If she fails to comply with these terms, plaintiff would be able to submit an affidavit of noncompliance to the court with a judgment for possession as well as an order of eviction. Copy will be sent to Ms. Thompson via mail. The 14-day notice and objection period is waived. The 56-day rule is waived. Neither party is waiving any claims or rights under the lease or the Landlord-Tenant Relationships Act. And no one is admitting any fault or liability.
So it's a 4A
It's a what?
on the conditional order dismissal. So 4A or 4B. Is she entitled to a hearing?
No.
No. Okay. All right.
And then if you could explain the 3-day rule.
I will. Ma'am, is all of that your understanding?
Yes.
Is there anything about that that you don't understand or have a question about? All right. And I take it that's not prepared today, the
No.
COD. All right. So when the conditional order dismissal gets to me, ma'am, you would have 3 business days from the date of my signing of that conditional order to dismissal to file to think about it, to file a motion. If you believe that there's some legal right you didn't assert, some confusion or misunderstanding regarding its terms. All right. It doesn't mean that I would set aside that conditional order dismissal, but it does mean that you have that period to think about it and then get before the court if necessary. You understand that? All right. Have any other questions regarding that conditional order dismissal?
Not at this time.
All right. Very good. All right. I will then mark this file conditionally dismissed, and then we'll expect to see an order shortly.
Yes.
All right. Very good. Thank you, ma'am.
Thank you.
These are
Yeah.
Avalon Housing versus Yolanda Shepherd.
Hearing for plaintiff. Jill Bauer here on behalf of Ms. Shepherd.
Your Honor, we have an agreement that we'd like to place on the record.
Go ahead. Yes.
I do just want to confirm, I don't believe there was a counterclaim in this case. Can you just confirm that?
I don't see a counterclaim. Oh, hold on.
I don't see one.
I don't see a counterclaim either.
Okay, well, Ms. Shepherd and all other occupants are relinquishing all rights there in the property and the lease premises. They are surrendering possession to plaintiff. We are dismissing the case without prejudice. Either party there's no finding of fault on the part of either party. And Ms. Shepherd wants it known that she's continuing to dispute fault for the case. And I think that's really it.
Okay, how are you going to do this? In the form of a conditional order dismissal or a
Like a straight.
stipulation to dismiss with the terms? All right. Is that a correct statement, Ms. Bauer?
Yes, it is. Your
All right. When is she surrendering the premises? That's today. Oh, well, that's probably why it wasn't said.
Honor. Yeah, and so I believe, Your Honor, you previously ordered that plaintiff was able to remove the items from her home.
Yes.
So that they could start the demo on these. I believe that there are still items that are now outside that she is going to be working on, hopefully moving.
I don't have privy to those details, but
In any event, she has surrendered possession. She's
Right, surrendered
abandoned
the
any
premises.
property that's remaining.
All right.
And
Then I will.
then, Your Honor,
Yes.
can she turn in any keys that she has?
yeah,
If she
well,
has any.
we can communicate that to her if.
Actually,
let's
no,
say-
it's fine.
Okay,
It's fine. Forget it.
Okay.
It's fine. She's already.
okay.
All right. This case is dismissed per the term stated on the record. Thank you. They ready on it? You said Mr. Friedman's not. Oh, okay. Okay.
This is our, I don't know if you want to do your recall. They're both here.
Okay.
Okay.
Let me just do this. Court recalls the case of the Totoro versus,
Good morning again, Your Honor. Eric would have on behalf of the plaintiff.
Good morning, Your Honor, and Your Honor, Darwin Fair on behalf of, and Your Honor, if I may, if I could just make one last statement, give Brother Counsel an opportunity to talk, if I can give just a little.
go ahead.
So, all right, Judge. Plaintiff counsel knows the posture. It's based upon what's happened in the past. So they filed a motion to close the case because that is the question, Judge, you always ask, and you wouldn't rule because of the circuit court. So they filed a motion in front of the Wayne County Circuit Court asking that the case be closed. And that was up for hearing a Friday ago. Well, we've been down this road before about a notice of hearing and a precipice. So the precipice wasn't accepted. But at the same time they filed the motion, Judge, they thought or presupposed on that date the judge would rule in their favor. And so at the same time, they filed motions for eviction in this court and also 35th District Court. Well, we both were alerted that the Wayne County Circuit Court was not going to hear the Wayne County Circuit Court case when they had noticed it for hearing. And I was notified by plaintiff counsel that, well, I'll let you know when the precipice is accepted, which means the hearings before this court had to be pushed off until after the Wayne County Circuit Court made a decision. So that is where the breakdown occurred, because then the Wayne County Circuit Court accepted the precipice for the 18th. And so initially the thinking was, well, let's just adjourn this case until after the 18th. I reminded Brother Counsel, we've been down this road a million times. What happens is whatever date that the Wayne County Circuit Court comes up with, oftentimes either doesn't occur, or if it does occur, that proverbial can gets kicked down the road. Then there was a breakdown, because at that point, Brother Counsel says, well, let's just go with the hearing, even though this hearing was initially scheduled because it presupposed the Wayne County Circuit Court would make a decision before we got before this court. And so that's why my initial argument for the court was, I don't know why we're here. So, Judge, I would like to defer any further argument unless the court has questions. So after Brother Counsel.
No questions. Counsel?
I have no objections, Your Honor, to the court entering the order of eviction, but not allowing its perfection until after July 28th.
Court having heard argument on this case, the plaintiff's motion to lift the stay to the extent that there was one and enter an order of eviction is granted. A writ of or an order of eviction may issue, but here's how I'm going to do it. I'm going to issue it with a firm date of August 1st, 2025 or thereafter. The 56-day rule on the issuance of a order of eviction is waived by the court. That, and so that the record is clear, that should give enough time should the defendants wish to seek other relief before the Wayne County Circuit Court. They may do so, and it is a period after the hearing, and actually it would extend the period out originally contemplated by the court. Regarding the 10 days, it extends it out a little bit more than that. So, all right, thank you.
Thanks, Judge. Always a pleasure.
The order,
I need you to prepare.
yes, Your Honor. Perfect.
Thank you.
Judge, can we put this on the record that I need to see the order before it gets signed, because Brother Counsel has a habit of sending orders that I have.
You know what? I'm not going to be between the council. Go out there, get a form order. You guys fill it out, approve it before you leave my building.
Sounds like a plan.
Yes, Your Honor.
Arbor One versus Rico McGuire. Et al.
Your Honor, Min Kim on behalf of Mr. Dwyer, as well as all of you.
Good morning, Your Honor. Deputy Gordon Lang here on behalf of.
All right. Where are we on these, man? Can I dismiss them and get them off my caseload?
We're okay with that. At this point, we, as we indicated last time before you judge, everybody that was on the docket has been no longer in a hotel. Everybody's been moved, everybody's been relocated on their own or moved to alternate housing. So there's no longer an issue with any of those tenants. The property's actively undergoing remediation. We've still got the two buildings, 720, 721 West Clark, 720 Green. They are ready. We are still waiting for city to allow us to have our COCs. Everything on the COC list has been done with the exception of two things that the city is requiring Arbor One to do, which is still air quality testing, which we are before Judge Hunky dealing with that. They are also requiring us to place baseboard covers that are fully functioning, but for cosmetic reasons. And there's also an issue of remediation of 4 small areas in the unit that did not pass the scope test. Those are the only things remaining in these buildings. We would, at this point, there are no health and safety issues from the property management team's perspective. So there's no reason these units should not be occupied, but the city is pushing back on that. So we have not gotten COCs yet. They've started the process on the next 3 buildings, 1431 LaForge, 1433 LaForge, and 772 Green. So they're working on those. Property management team says timeline from when we started should be 7 to 8 weeks. Could be less, half the time and half the money without the requirements the city is placing on us, but we work with what we're given. So they're actively working and they're moving down the list to the next buildings. So things are ongoing.
No. All right, so go, Ms.
If I
Kim.
may, Your Honor.
Yeah, go ahead.
I don't think it's correct that all the tenants have been relocated. I know that, for instance, Mr. McGuire is still looking for other housing. And I'm sure the court is aware of Judge Kunke's partial preliminary injunction, allowing the tenants some options to relocate.
But yeah, and I don't mean to interrupt you. Is that where there was the agreement that the tenant would sign that they would leave and
That
then?
is correct.
Okay.
And I believe we had some emails with Anne about what the court required for the release of escrow, whether they can just submit the move out agreement, the court order move out agreement, or whether they have to file a motion with the court.
And I don't know I don't know how Ms. Wadling responded, or did we respond to you on
I
that?
think that you were waiting for a copy of the order. And
Well, right, because I think that was right before a hearing. But so there was one case, I'm good. There was one case where what we did is the tenant came up, provided the agreement to us. It was signed off both by, I think, Beal and by the tenant. I read the agreement. The agreement made sense as to what it was saying. And so then I issued an order releasing the escrow pursuant to the agreement and attached it.
Correct.
That is how I thought all of the other ones that were going to happen that did that would take place.
So they do not need a motion. They just need to.
I don't, somehow or another, it has to be. They don't really need, I mean, I hate to go through the whole process of filing motions on it because it is rather straightforward. Just so you know, the young lady that did the other one, she brought it up to the court. Clerk didn't know what to do with it. Got it to us. I read it and then I did the order. Okay, because I understood what was going on. Would I need a formalized motion? No, but would I need some way to recognize that we're receiving it? Because if it's what that person did, I'm gonna issue the same order. I mean, it's not like we've got to reinvent the rule.
Tenants and the tenants union about what the court needs with that document. If there's anything additional.
No, but I just have to have something that says I'm submitting this stuff. You see what I mean? I mean, I can't just have loose paper flowing
Like
in.
a cover letter, you're saying?
Yeah, that's fine. And just direct it, or if you know the tenants, they could just send, you guys could send us an email asking us to issue an order releasing the escrow. Okay.
And,
I just want to make it as simple as we can.
and I just wanted to add to, Sister Council's summary that, I just got a update from, one of the city's attorneys this morning about the process of the administrative reviews, where those are. And apparently Arbor One lost the appeal to the County Board of Review, Construction Review. And also, I guess the other appeal before Judge Conkey is still pending. And at the hearing on Friday, there was testimony taken about the air quality testing, and that evidentiary hearing is continuing on July 10th, I believe, at 9 a.m. And there was some discussion about whether there should be a neutral, not neutral, but I mean a outside third-party inspector involved in all of this. And a conservator was appointed last week. An order is about to issue soon. I think those are the additional updates that I can think of. There is one other concern, Your Honor. A lot of the people that were relocated by Arbor One to the villa side, are you aware?
Go ahead. I'm listening.
They're paying money into escrow as this court requested, and they're being sued for eviction in 14B.
Correct.
And we are representing a couple of them, but it's a big concern.
I had talked to Judge Washington about that. All right, because now these cases are flowing over into various jurisdictions. Certainly, I think that those issues could be resolved in one of two ways. One would be to file with this court an order to either if all the issues are resolved, we would just pay out what's in our escrow to the landlord.
Resolve
Okay.
what way you're-
I mean, if the tenant's suing the landlord, the new landlord that's in the 14B jurisdiction, the villas, and all the issues are resolved, it's just an issue of money, then in order to this court saying that can be paid to the villas, I would sign off on something like that. If the issue is that there's going to be some litigation surrounding that, then it would seem to me to submit an order just requesting that this court transfer the escrow to the 14B district court on whatever that case number is.
I'm not quite following, Judge. So these are non-payment eviction cases where the tenants are paying their rent into court escrow here. So
Correct.
you're saying you want the escrow just transferred to 14B?
There's going to be one of two things that are going to happen with the escrow. I guess there's a third option. Either the escrow is going to be subject to the order that Judge Conkey issued regarding the distribution of that, because that person has technically given up their other unit. So under that order, it may have to go to the tenant.
So under Judge Conkey's order, if you have asked Arbor One to temporarily relocate you, then
It's
you're not
50%.
getting a refund of the monies right now.
I thought As I read it, it was 50%.
They're supposed to be paying, if you're asking for temporary relocation with the intent of coming back to
Right.
Arbor One, placing a unit that has a COC, or when your unit gets a COC, whatever that winds up being, they should be paying 50% of their rent from wherever they're relocated to.
Right.
If they're being relocated permanently with no intent of coming back to Arbor Run, and they're being relocated to a place that has a COC, there's no reason why folks should not be paying rent in a unit that has a COC. Judge Kunke's order is very clear that rent is only abated if there's no COC. So if these folks are intending on staying wherever they are, they should be paying full rent to Arbor One. And I will say, Your Honor, we are not handling the township side, so I can't speak to any of the actual.
Of course not,
cases that have been
right?
filed. But I would presume that if they're not paying the rent to the landlord and they're intending on staying there
Okay.
long term, that's
This-
why. it should be filed.
And
disagree
right,
with- I
that,
dis-
go ahead.
I disagree with what, first of all, there's nothing in Judge Kunke's order about paying 50% of.
Oh, no,
Yeah.
that's the way I read it. The agreement was that if they were voluntarily surrendering the unit without an intention of coming back, they would get all, for our purposes here at 14A, they would get all of their escrow. Right?
If they're giving up and not coming back.
If they're giving up and not coming back. The part I didn't know what to do with, because my understanding was there's this 50% split, is that if they went someplace else, I don't know what to do. There has to be an order or something submitted to the court as to what to do with that escrow. Because my understanding is there was this 50%, which I didn't understand, but it wasn't my order. There was the 50% split to, let me see if it's in this
There was
tenant.
some discussion, Judge, about the 50% because tenants who are placed in hotels had no way to cook their food, et cetera, but I don't think that language made it into the order.
It's not in the optional move-out agreement. I can tell you that much.
Judge Kunke was very clear on the record that her intent was to have residents who are requesting to be temporarily relocated pay 50%. She very clearly asked legal services, Blue, I believe specifically, whether or not she would rather not include anything in the order with regards to temporary relocation and kind of let it be what it may, or consider it or order that tenants pay 50% of their rent and make that decision.
It might have just been an oversight, but it's not in the order. But I would have to say that I believe the tenants
I don't know
in
that
your
that,
court are paying, actually, I think they were paying their full rent into the court escrow here.
correct, because we didn't, because the allegation that was raised was that they were being relocated by Arbor One to the villas in the township. There were issues that were raised as to the fitness of those units. Okay, I don't know anything about that. Those aren't my cases. So the tenant asked me, what should I do? I said, well, we have the escrow open. At that point, there's no case at 14B. I'm aware of that. So I said, just continue to pay your rent here with the thought process that could be that the financial pieces could be straightened out rather simply by virtue of an order. If they were sued in 14B and there's an issue, I don't know why you couldn't submit an order to the court just asking us to pay those funds over to escrow in 14B.
So from what I understand, Judge, the tenants that have been relocated to the villas, some may have signed leases to stay there permanently, but the tenants that we're representing, they're there temporarily until their units get their certificate of occupancy. They're in. small
Okay, that's
units that
fine.
They want to be, or their conditions aren't right, or for instance, there's another tenant who's.
Well, what are you asking me to do though?
I'm not sure what the right thing is, Your Honor. I don't know if a 14B should have jurisdiction over those cases in a non-payment case when they have been paying rent. There shouldn't be a non-payment eviction filed at all.
And that may be, I agree with you in the sense that that may be your defense to their claim. And when they filed the case in 14B, your defense of that is they've been paying their rent all along. Right? It's just happens to be here because they got relocated there. So the way to resolve that, it seems to me, is in one of two ways. If those folks are going to be coming back, would be to take the escrow I have here, get an order to send it to 14B to be held as escrow on that case. That would seem to me to be the simplest thing, and then that has to be litigated over at 14B.
And then what would happen to their case here? Would it be stayed?
Why would I stay that?
I mean, they have counterclaims. It's not just about the rent being paid, as you know. Judge Simpsons ruled that Arbor One did not have the right to collect rent since September 17th.
Correct.
So in some
So
aspect, they should just get the escrow released to the tenants.
I don't have a problem, even if you do the math, with that concept of it coming back to the tenants, if that's what Judge Kunke ruled. I don't have a problem in that. But there's a point at which they're now in the township. Right? They moved. And I don't know that these folks, but you're saying these are not folks that have signed leases. These are people that are just temporarily housed there and are coming back. So let me think about that a second. It would seem to me that those folks that are temporarily housed there and are coming back, that I would release or do whatever with that escrow consistent with whatever Judge Kunke's ruling is.
Judge Kunke's ruling and the move-out agreement with regards to the release of escrow are specific to the folks who are entering into this move-out agreement. These folks that Sister Counsel is talking about are not subject to move-out agreements. There's three options that folks can select. They can select a move-out agreement,
Right.
break their lease, and they receive a refund. They're gone. They're finding their own housing. They're leaving. They're doing that. Folks can choose to stay in their units because, quite frankly, a lot of these units have been turned and are perfectly fine, and they are just choosing to stay. Or folks have the option.
And well, let me ask that. So if they stay, they pay rent?
People who are staying are
Whatever.
electing not to pay rent. There are folks who are voluntarily paying rent because they have some sort of other obligations that they recognize, whether it be some sort of assistance or just recognize.
Whatever. Okay.
So, or there are folks who can elect to be temporarily relocated by Arbor One, and with the intent of coming back when they get placed in a COC, a unit with a COC, or their unit gets a COC. So the release of the escrow portion of the move-out agreement is only for those folks who are entering into those move-out agreements. There's been no discussion about release of escrow or anything of that nature with regards to any of the people who are electing the second two options. So I'm not sure why we're talking about escrow with regards to the folks who are temporarily relocated, because they're not even subject to that issue.
Well, right. And so
I don't disagree with what she's saying, Your Honor, but I think that transferring the escrow to 14B means that Judge Washington will be hearing all of the same issues that this court is hearing, and it doesn't.
welcome to the wonderful way we've set our courts up.
I think that, I mean, I might have to confer with my team, but I think that the 14B cases should probably be dismissed because they are not really not paying their rent.
Well, and I may, for those that have not signed a lease. So if they move over into 14B, sign a lease, then, and they have escrow here, then this move out agreement is what would apply. right? Because they permanently relocated, they said, I'm not coming back. If they moved over and it's a temporary housing until there's a CO, I don't even know how a case is being filed against them.
That's what we're saying, Judge.
But that's not, but hang on a second, that's not my call to make. I mean, if it were before me under the circumstance, I could tell you what I'd do, but Judge Washington may have a different view of it. And that is, I'd say, well, they're coming over here because their unit is not what it is. So I don't know why you're here asking for non-payment. Because really, everybody's just hanging on to these cases because your unit isn't up to date.
And
That, I mean,
there are motions that are going to be heard on July 9th on this issue with Judge Washington.
so you guys have managed to get at least 3 judges
I'd
involved.
rather just put in one form, Judge, and I'm renewing our request to stay all of it.
These cases?
Yes.
Well, I think what I'll do is I'm just gonna give another date, because so let me just throw something else out there so that everybody knows also why my life becomes difficult. There are tenants who were Arbor One tenants who have relocated to other complexes outside of the villas that are within my jurisdiction, who are now also before this court by their new landlord for not paying rent. It seems that the landlords and the tenants are aware of their circumstance. But I don't know what posture is being taken with regard to the new landlords. And some of these new I think the ones that I just heard, I think they're all Beal properties.
Okay.
But I don't know under what circumstance. There were, I think, 2 individuals this last docket. I don't know under what circumstances they went. So I don't know if they went and it was a temporary thing and then they were going back.
Anybody that was relocated outside of the villas was not, my understanding, though, the only temporary relocations that have occurred have been to the villas. I don't believe that anybody.
I don't think that's correct. There was a order, Judge, where you said any Beal properties portfolio, properties available in their portfolio that they were transferring them to as well.
Well, I don't know that I mentioned anything about Beal properties. The only thing I mentioned was the villas, because I knew they were going across the street to the villas.
But Beal properties opened up their portfolio to the tenants who.
Yes, I recalled that happening.
And those folks have been signing leases, is my understanding. So those have not been temporary relocations.
I think that.
And see, here's my problem. I hear what you're saying. I don't know that.
Another wrinkle, Your Honor, I think that tenants who signed leases may have felt like they had no other option if they wanted to stay in that new property. If you recall.
I remember.
Beal was making them pay application fees and new security deposits and having them sign leases. And I don't know if the tenants were aware that they could refuse to do so. If you have the
I had 160 cases. I don't remember those 2. You do? Okay, well, then we can get those to you. But I don't know what the status of them is. And now I have this other landlord involved, but I don't. So I'm not sure what to do with those. And I'm not sure how many there are out there. But it would seem to me what council's indicated makes sense, that if they're in these other places, they may have signed a lease. And that's, and I'll tell you, Ms. Kim, that's what I assumed until you said what you said this morning about the people in the villas getting sued. And they didn't really sign a lease. So,
We have to contact these tenants and, you know, if they're a client with us and see what's going on.
right, so on these cases, what do you guys want me to do? Because
Judge, honestly, we would request to stay until there's a decision by the circuit court on, you know, whether when they get a certificate, they may determine how much rent they owe, if any.
well, hold it, but this is what makes this so bad. Once the circuit court gets done, and maybe I'm wrong, I'm presuming that they're going to go through for those tenants that dispute as to what rent is owed. There's all that stuff coming back here. Because if it is, oh boy.
Ideally, Judge, would be a overall settlement so that you don't have to, you know, look at every single individual case and there'd be a global decision.
I mean, we see no reason to
From your lips to God's ear, but I don't know.
continue to keep these cases. I think there's obviously a question of money being held in escrow and what's happening with that, but outside of that, I think
these cases run the course, we should dismiss them.
Well, I get that. But you also maintained that from the beginning, but
I'm concerned.
exactly. But what I'm hearing from Ms. Kim is there would be basically a general objection to that because there may be claims, but
There are some cases of counterclaims. Your Honor.
yes, there are.
The proper thing would be at some point to remove them to circuit court. And we can certainly continue this conversation between us, amongst us, about whether we should just dismiss all of these. But at the moment, we would ask that they be stayed.
Well, and part of my problem is this. I can't dismiss all of them because I don't have a disposition of the escrow. I
guess I was under the impression that she meaning Dutch County had taken jurisdiction of the escrow.
I don't know that.
I mean, I think at this point, the only reference to escrow was in the move-out agreement. There's been no other discussion or disposition of the escrow other than them being able to apply to this court, or if they're subject to a move-out agreement, for court to determine whether or not to release their escrow. And,
Right.
and we've had one of those requests so far. And
Are you
obviously,
talking Ms. Gamble?
yes.
Yes.
What you entered the order for. And then I believe there's another motion later today, but she's not subject to the move-out agreement as she moved out prior to any order was entered. So that's a totally different situation and request. And so from our position with regards to the escrow, and you'll hear this later, the escrow should be released to be accessible to the landlord for remediation by statute. Your Honor already got it correct by ordering these tenants to put the money in escrow. And so, you know, you've been taking the position that we have to determine what's going to happen, and that will happen at a, you know, later date. You know, we're maintaining that this property is actively undergoing remediation. Statute is very clear that says if there's no CFC, tenant should be paying into escrow, and that money should be used for the purpose of remediation.
It can be, right.
Yeah, and so that's, if we're getting to dismissing these cases and dealing with the escrow, that's, you know, what the escrow should be used for in our position, so.
But I don't know, and maybe or maybe not agree with you on that. I don't know what tenants are still there.
And that would impact whether or not the escrow was released for remediation purposes or?
Right, so frankly, I don't have enough information because I don't have the whole case. So I don't have, I may have a tenant that has escrow in here. I'm unclear what to do with it because I don't know, should this tenant be subject to the move out agreement? Have they voluntarily done whatever? Are they just temporarily there, either by virtue of Arbor One putting them there? Or did they kind of voluntarily move themselves temporarily and they're intending on coming? I don't know. And I think those things, the escrow, what to do with the escrow becomes different as to what to do with the escrow just on those scenarios, and I'm sure there can be more. But Mr. Friedman, if you're saying Judge Kunke took jurisdiction of the escrow, I'll say I'll be good.
I'm not sure she did, I'm not sure she did. Frankly, to be blunt, some of it's kind of confusing because she's saying it can be used for this and she, in a sense, she took jurisdiction over the escrow because she said what it can be used. She said that it can be used for certain purposes. So,
You mean in terms of remediation of the
So
unit?
I believe Mr. Friedman's referring to the terms of the move out agreement.
Got it. Yeah, so I don't have any problem. Once I saw the move out agreement, like I said on the Miss Gamble, I don't have any problem dealing with it, how I dealt with it, of just issuing the order once I had the signed agreement and we attached that to it. Didn't have a problem with that. That's the only case I've got.
Yes, Judge. There are people I'm sure moved out before the order was issued and
Before which order?
Judge Kunke's order. And unfortunately, those tenants, they can't access the benefit of that agreement. Maybe we could can I propose that we?
Oh,
Status.
because they,
Moved out prior to, the move out agreement is specifically for folks who are currently at Arbor One, who wish to break their lease and leave to find their own alternative housing. And so if somebody's vacated months and months before, they can't now come back and say, oh, I now want to enter into a move out. They've already moved. It's a move out agreement for folks who have not moved and are still at Arbor One. So there are folks who have already been relocated or who have already decided to leave on their own. And so that money and if there's being held in escrow, it's our position that should very clearly be used for remediation purposes. With regards to the folks who are submitting move out agreements currently, who are planning to leave Arbor One and who are currently residing there, I can understand, Your Honor, that could be a different situation as to looking at what's to be done with the escrow. At the end of the day, our position is the statute is clear. Any money that is being put into escrow with regards to somebody who is living at the unit when there's no CFC, that money should be directed to remediation. And so, quite frankly, it's kind of all encompassing with regards to the statute. The statute trumps the ordinance, which says that they are not required to pay rent with no CFC.
Your Honor, I disagree with the interpretation of the preemption issue, which I think was part of Arbor One's motion recently that Judge Kunke heard on Friday, and it was denied. The preemption issue, because the city code says something else, and there's a statute that says that the municipalities can have a higher standard or more protections for the tenant. So we're not asking the court to rule on that today.
and I'm not going to.
And council keeps remediation, but I think that most of their funds are going through litigation, honestly. And
Not like
they have said many times that money is not an issue with making all of the repairs in objection to having a conservator. So I think the little bit of escrow that this court is holding right now is just tiny little pennies that will not really make that much of a difference in their remediation efforts. That's just my opinion, Judge. But I would ask that you give us an opportunity. We can come back to talk about potentially dismissing these cases, but we would have to deal with the cases.
You're coming back.
With counterclaims. Unless you just.
I got you. And I think what I'm gonna do is I'm gonna give you a date into the future. Let all of this sort out. I am always available if you guys have resolved certain things to it, if you resolve a particular case, I don't have a problem issuing an order doing X, Y, and Z. I mean, I'm not gonna have an issue with that. One other issue do I dare say, so I'm gonna need something about a month and a half out, please. There is this large monies that I had, or large relatively speaking, in this case, like 50, 60,000.
Oh, 65.
65.
Yeah.
So did we,
I have reached out to the city's attorney to inquire on several occasions about them submitting something to the court pertaining to what that money will be used for. We would like it to be used for inspections fees pertaining to these two buildings and applying those. I've got nothing back. At this point.
okay, well, something has, all right, no, I hear you. And something has to be done because those funds were paid in good faith. Because there was this rather bizarre notion that there were bills that weren't paid, so they couldn't move forward. And so I said, well, how many bills do they have to pay? And what are the bills? And they couldn't give me what the bills were. And then an odd thing happened that really does bring it to light in my mind. The amount that was owing on those past bills, typically I would have thought that Arbor One would have given me a lower figure that was owed, as opposed to what the city was saying. But the city gave a lower number. Arbor One gave me the 65 or whatever it is. They paid it in good faith. Since it was taken in under those circumstances, there needs to be some, they said they couldn't take it and then apply it to what bills, which was bizarre to me. But I thought I was going to get a list.
And we've asked for that. I've got emails to the city attorney asking them very specifically to ask their client to prepare a list. It's become incredibly problematic as of this week as well, because we've got this money being held that we would like to be used for fines, and the city has now filed 40 some liens against us for fines. And so that's happened as of this past week. And so this is, the type of things that we were hoping to avoid. And so now we have to deal with that because the city won't get back to us about, and this is, and like I said, we're moving on to the next 3 buildings. And so we're trying to get this going, but we can't even get the money applied for the 2 that we're dealing with now. And so that's been an issue. So I don't know what more Arbor One can do with regards to reaching out to them, because that has to come from the city. We've made their request as to what we would like it to be applied to. But yeah, I mean, I can reach out again today after the hearing and indicate that.
Do you have, that the number you gave council, I'll tell you what I'm going to do. We'll just do it this way. When you paid the 65, whatever in, you had certain bills.
Well, they actually had returned checks, if you remember.
Correct.
That were good.
So yeah,
We're talking about NSF checks. We're talking about checks that were not stale.
$50,000 checks. So yes, we had numbers. We were able to pull from the BSNA website or pull from our own records and see what was due. So we could, if the city's not going to do it, in order to get the money, we can pull the numbers together for these 2 buildings and see.
Here's what I'm going to do. I think go ahead.
Sorry. I just feel like releasing the money to Arbor One.
No, it's not. No, that's not. It's going to the city.
But Your Honor, that is going to the city for payment of Arbor One fines, right?
Not
Is that what we're
inspection
talking
fees.
about?
Their inspection fees,
Your Honor.
which is why I took it in the first place. I mean, I don't know if you were at that hearing, but it was bizarre to me what the city was saying to me. The city was saying, we will not do any more inspections because they haven't paid these fines and whatever in the past. I said, okay, well, how much do they owe? And they gave some figure. Hold on. No, you need to hear this because this was bizarre to me. And then I said, well, if they each had a number, and I said, well, just pay it to the city and they can sort it out and apply it to whatever bills are owed. They then said, oh, we can't take money that way because they don't want us to. They don't know who they are and what that meant. So then it ended up that I took the higher number.
Was the number plus 20 or 25%? It was 20,
Yeah.
I think it's 25% over the number.
Whatever number it was. Anyway, that I took that in and I said, okay, with the thought, get me the bills that need to be paid, get an order, we'll release the checks, those will be paid to not hamper further inspections on the premises. That was the intent.
I guess, Your Honor, what I'm trying to say is that these funds belong to tenants.
No,
They do not.
no, these don't belong to the tenants.
Until it's litigated or.
No,
there's decision
these
made.
funds don't belong to the tenants.
She doesn't have a dog in this hunt.
Yeah, I know. The funds that we're talking about, Ms. Kim, are not tenant paid or landlord paid escrow
Oh, okay.
for that.
What are-
It was taken into escrow so we could, just understand this. So that the bills and fines that the city was complaining about could be paid so that further inspections could happen. Because the city would do nothing unless this was paid.
But the funds that we're talking about, are they not escrow funds from the tenants?
No,
Oh, okay.
no,
what are the source of these funds that we're talking about?
these were the landlord's monies that they were gonna pay to the city of Ipsy that the city of Ipsy wouldn't take.
Privately held money from the landlord.
Got you. So we're not talking about tenant escrow at
No,
all?
Not at all.
Okay, we've moved along. I'm sorry, Your Honor.
We did that about an hour ago. Nice of you to catch up. All right.
Glad we're on the same page.
No, I bring it up because I need I'd like to dispose of that.
We can get, that would be.
So here's what I'm gonna do. I'm gonna order that the parties that I have before me are to provide me a list of how those escrow funds are to be dispersed and to what bills they should apply at the city of Ipsy. You're to do that within 10 days.
This is not tenant escrow.
This is not tenant escrow. This is the funds that we're holding for the payment of that,
And how much is being held, Judge?
about 65,000,
The dollar amount on that big check was 62,000.
62,000. All right.
And can I ask if the court knows how much tenant escrow is being held here?
We absolutely do. Give it to me, please. There's an additional 10 though.
Mhm.
So it's going to be 21,590, right? For their
590, Your Honor?
So the plaintiff also
head to,
had, right,
Right.
correct. Yeah.
okay,
And then
so
this is
we're at about
specifically-
20, right?
And are tenants continuing to pay for escrow right now?
I have no idea. I don't know when the last payment we got. We updated occasionally, but. Okay. What I have is I have about 84,000 that I'd like to dispose of in some fashion. 62 of that being what was paid to the bill. So I'm ordering, let me just get back to that. I'm ordering that. That's to be submitted within 10 days. And I suggest let's do it this way. Submit it under the 7-day rule to me.
Both,
No, for the 62.
but you want both of us to submit a 7-day?
No, no. Really, Miss Kim, you're not in. The tenants aren't, the tenants really weren't involved in this.
We can,
This 62 was paid by we were looking to get repairs moving and inspections moving. The city said, and I'll just say it again, the city said they could not do inspections because they haven't paid this, whatever. So I said, well, how much is owed? We came to a figure. I said, well, go ahead with the inspections. Now the court has some money. Right? I don't know that that's occurred, but anyway, I had the money. I then asked the city the last time they were here to basically give me a breakdown of what bills it should be applied to because they said they couldn't take the lump sum and do it themselves. Okay, I've got nothing. So now I'm ordering parties to give me something, file it under the 7-day rule, and then those particular funds I'm going to disperse for that purpose. That's what I'm going to do. Because
you said under the 7-day rule, okay.
Yep.
So not 10 days?
well, you have 10 days to do it, but submit it under 7. However you want to do that, because there's different reading of that rule.
Okay.
I'd like it sooner. I'd like it sooner than later.
I will just
And-
note one other thing. I noticed. Just
No, go ahead.
knowledge. I believe that Ms. Kim mentioned that she received information that our appeals had been denied by the Board of Appeals, which we did appeal the red tags to the Washtenaw County Board of Appeals. They did deny those, but we've appealed them to the State Commission, and those are pending.
Got it.
So that is still all in place. No decision has been made. I believe the meeting for that are July and October, respectively. So we will be dealing with those accordingly. And as Ms. Kim also mentioned, Judge Kunke on her own mentioned to the parties on Friday about sua sponte, ordering a independent third-party inspector. We've been making our claims to her that, there's a lot of stuff going on here with, disparate treatment. So seems like she's hearing that. And so we're briefing to her by Thursday her authority to do so, and why that would, substantially benefit the process of getting these buildings online. So that's being briefed to Judge Kunke by Thursday. And so, yes, I think that was all of the major updates here.
All right, real good. Then what I'm going to do, other than the 62,000, I'm not going to do anything at this point with any of the escrow, except as is consistent with Judge Kunke's order, if there's a move out. Otherwise, I'm not doing anything with it unless the parties agree that it be sent someplace else. I'll get that other order and then we'll adjourn this to all of these.
Tuesday, August 12th at 9 a.m.
Tuesday, August 12th, 9 a.m. And then we'll see where we are. Okay,
Thank you, Your Honor.
thank you.
Enjoy your summer.
Huh?
Enjoy
Check
your
that
summer.
date really quickly, Your Honor, if you don't mind.
It's too late. I'm not going to enjoy my summer.
That Tuesday, August
12th. Yes,
Okay, that works, Your
it
Honor.
works. All right, fantastic. All right, thank you, folks. Did they have an order?
I'm sorry?
Those two, did they have an order?
Yes.
Where is it?
There's a motion on it.
What?
If I were right. Also the motion, I didn't know if you were addressing it. now.
Oh.
They have it.
There is a motion, another motion.
Yeah.
Let me get this order here.
Yes.
Yes.
That's the order.
Do you just info for Your Honor that they have something to say? Or
No. We're not going down that road, Your Honor, please. If she won't file an appearance and she wants to, it's not appropriate for her to interject herself into this without being on the record, period. I'm not. Once again, she doesn't have a dog in the hunt.
I've signed this. We'll get copies to you.
It's a dog.
Thank you. We don't fight dogs anymore.
Oh, right. Gonna have PETA down here in a minute.
I know when the motion was submitted, there was submission statement that she's not represented. That's, to my knowledge on. It's submitted for her, but she's not represented by counsel, so, we're prepared to move forward with.
Is she here?
She was in this. She's possibly dialing.
Hello,
We have one.
Hello, what's your name?
Denise Llewellyn.
Okay, Miss Llewellyn, I guess I'm gonna do it this way. Are you intending on being represented by counsel? Pardon?
Yes, legal aid. Sign was legal aid.
Yeah, okay. Are you guys gonna represent Miss Llewellyn and file an appearance and answer?
File an appearance and do not intend to represent Your Honor. But we are very familiar with the situation, and if the court has questions, I'd be happy to.
Yeah, but Mr. Friedman makes a good point. I mean, I don't know who's, from the court's perspective, I don't know who's answering back. I mean, it's sort of, I'm getting these sort of phantom arguments, and I can't. It can't operate that way. More importantly, Miss Llewellyn, I mean, in fairness to her, I think she believes she's being represented.
I've
But
been dealing
she-
with this since
Pardon?
since court started. I said I've been dealing with legal since we've been started almost a year ago. With
Okay,
Arbor
you broke
One,
up there.
know.
Say that again, Miss Llewellyn.
I said I've been talking to legal aid since Arbor One been going to court. So I thought I was represented because I've been talking to them. I've been emailing them. They've been emailing me back. I don't understand what's going on now.
I believe that Ms. Llewellyn was.
May I approach?
Because I've been trying to break my lease.
Okay, hold on, Miss Llewellyn. Okay, folks, in this matter, record should reflect, we've had a brief bench conference. Miss Llewellyn, I'm going to adjourn your matter to July 8th, 2025 at 2 p.m.
Okay.
Okay? During that
Okay.
week or so, I need you to talk to legal services. And my purpose in adjourning it is so that there's a clarification on whether or not they are representing you or whether or not you are going to proceed on your own.
Okay.
All right? Thank you.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
This shit is retarded.
That's it for this morning.
It is.